Most people don't lose their small claims case in front of the judge. They lose it at the kitchen table before they ever file. In this video, I'm going to walk you through 5 preventable mistakes that quietly kill small claims cases before they start, and what to do instead so you give yourself a real shot at winning. I'm Patrick Nolan, an attorney and author of Small Claims Court Handbook, How to Prepare, File, and Win in Any State. I've watched a lot of good cases go bad for avoidable reasons long before anyone ever steps foot in a courtroom. Small claims is meant to be the people's court, fast, simple, accessible, but it still has rules. If you miss the basics on jurisdiction, deadlines, paperwork, or proof, the judge's hands are often tied, even if you are absolutely right on the facts. Fix these 5 and you are way ahead of most people in the courtroom. Mistake number 1, filing in the wrong court for the wrong amount at the wrong time. Look, you must file where the court has jurisdiction. That's usually where the defendant lives or where the problem happened. Every state caps small claims amounts, typically between $2,500 and $25,000. And there's a legal deadline to file. It's called the statute of limitations. A lot of people rush to the courthouse with a good case and bad paperwork. They file in the wrong county because it's closer to home. They ask for more than the small claims limit allows. Or they wait so long the statute of limitations quietly runs out. On hearing day, the judge will have no choice but to toss those claims. Imagine you're owed $7,000 in unpaid rent in a state where the small claims is capped at $5,000. If you file for the full $7,000 in small claims, in some states the court can't even hear it. If you split it into 2 cases, $3,500 and $3,500, most judges are going to see that as gaming the system and dismiss both. And in some states that's illegal. Some states, like Missouri, if you file in small claims, you will waive any amount over the statutory cap. So if the amount is $7,000, you can only sue for $5,000 in small claims in Missouri. The other $2,000 is forever void as a matter of law. Does that sound familiar? Drop a comment below if you've been caught in one of these technical traps. I read every single one, and I will answer questions that don't require legal advice, but I'll answer your questions. Mistake number 2, skipping settlement amounts and a strong demand letter. Look, small claims courts expect you to try resolving disputes first, through conversation, payment plans, or mediation. A written demand letter is often required, and it shows you acted reasonably. If it doesn't work, it could become powerful evidence in court. Too many people skip straight to, "I'll see you in court," without a calm conversation or a formal demand. Others send an angry, rambling email instead of a clear professional letter. Judges read that tone. A simple structured demand letter lays out what happened, what you want, and a deadline often resolves a problem without a lawsuit. And if it doesn't, it can become powerful evidence that you were the reasonable party. Let's say that you paid a contractor $1,200 and they never did the job. You call once, you get frustrated, and you immediately file suit. Compare that to someone who calls, commonly asks for a fix or a refund, sends a demand letter summarizing the facts, naming the amount owed, and giving a firm 10 to 14 day deadline. They save copies of their emails, their texts, and the green certified mail card. When both people show up in court, the second person looks prepared, patient, and credible. The first looks impulsive, and judges notice that difference. Mistake number 3, suing the wrong person or the wrong version of the business. Look, I've been on both sides of this. I've seen it, and I've responded to people who actually sued as the wrong entity. Okay? If you sue the wrong defendant, you can win a judgment that's worth exactly $0. The law cares about the legal entities. Sue Jane Smith personally when you should have sued Smith Repair LLC, and your judgment can become worthless. In the rush to file, people often write down the name they see on a storefront, or the first name they remember from a text message. You hire Quick Fix Roofing and pay them in full. The receipt shows Quick Fix Roofing LLC, but your claim lists Jim the Roofer, because that's what he called himself. You go to court, you tell your story. The judge rules in your favor against Jim personally. Months later, you find out the bank accounts, the tools, they're all in the LLC name. Your judgment doesn't touch them. Same facts, a wrong defendant, and pretty much a useless result. Yes, you still have a judgment against Jim the Roofer, but Jim the Roofer can overturn that judgment, especially if you didn't serve him properly. Okay, this next mistake is even more common, and it's the one that causes the most delays and dismissals. Stay with me because getting this wrong can add months to your case. Botched deadlines and service of process. Service of process, legally notifying the defendant, the correct defendant, isn't optional. If you don't serve the defendant the right way, on time, the judge may delay or dismiss your case. The court requires specific service methods. Personal delivery, certified mail, or through a process server. Look the rules up and follow those rules exactly. People assume that sending a copy of the claim by regular mail or handing it to a relative is good enough. In small claims court, the court's going to give you some grace, but they're not going to rewrite the service rules for you. And if the defendant can honestly say, I was never properly served, the judge's hands are tied. You file your claim, you put the papers in the mail yourself, the defendant doesn't show up, you're hoping for an easy win. Then the judge asks, how did you serve the defendant? And you say, I just mailed it. Well, in a court that requires certified mail or personal service through a sheriff or process server, that case isn't going forward. The judge will either reset your hearing or dismiss your case entirely. Mistake number 5, walking into a court without a case plan or organized evidence. Even in small claims, you have the burden of proof. You must prove what happened and how much you're owed. Disorganized evidence, random receipts, 50 unlabeled screenshots, no timeline. This makes your story hard to follow and easy to doubt. A simple trial binder with a timeline and number of exhibits can make your case clear and convincing in 10 to 15 minutes. Judges don't have time to organize your evidence for you. Organization is your secret weapon, a master list, labeled exhibits, and a one-page timeline. Look, here's the thing that trips up even experienced people. And honestly, I've seen lawyers mess this up too. The difference between winning and losing a case often comes down to how you present, not just what you present. Picture 2 plaintiffs. The first drops a pile of cumbersome receipts on the table and talks in circles for 10 minutes. The second walks in with a binder labeled Nolan v. Smith and hands 3 neat sets of exhibits and says, Your Honor, exhibit number 1 is the contract, exhibit number 2 is a receipt showing I paid, exhibit number 3 is the demand letter they never answered. Both people might be right on the facts, but only one looks like someone the judge can confidently rule for. If you don't want to learn all this the hard way, my Small Claims Court Handbook, How to Prepare, File, and Win in Any State, walks you through these steps in plain English. How to check jurisdiction, dollar amounts, write an effective demand letter, pick the right defendant, handle service, and build that trial binder. I will put a link to that in the description. If you found this helpful, hit that subscribe button. Right now. Seriously. Do it before you forget. Because in my next video, I'm going to break down exactly how to write a demand letter that actually gets results. And will impress a judge if you end up filing anyway. I'm Patrick Nolan. Thank you for watching, and remember, most small claims cases are won or lost long before you ever see the inside of a courtroom.